All right, so it looks like we've got a pretty good group here. Thank you all so much for joining us today and welcome into the Enhancing Your vLex Fastcase Benefit webinar. Hopefully for many of you, you've already familiarized yourself with the vLex Fastcase platform and you're here to learn how you can take that platform to the next level. Now, I'd like to begin today with highlighting our mission, which is to continue to democratize access to the law, but we also aim to revolutionize how attorneys engage with legal information. As I'm sure you're aware, technology is advancing faster than ever, and AI is at the forefront of this transformation. And while we still preserve the traditional research methods and platform, methods of gathering information, analyzing data, and making decisions are being replaced by AI-driven solutions that are faster, sometimes smarter, and more efficient. And the tools and content that we're going to explore in detail today focus on the second half of our mission, which is the revolution of how attorneys engage with legal information. And we're very excited to show you these in action, what we've been working on. But before we introduce you to Vincent, I'd like to introduce our presenters today. I'll begin with myself. My name is TJ. I'm a customer success representative with vLex, specifically for our alliances or our bar partnerships. Many of you may have already received an email from me once you've onboarded into the vLex Fastcase platform, but I want you to think of me as a resource to you at any time. So if you have any questions or feedback while you're exploring any of the products and platform features, please don't hesitate to reach out to me. I'll be providing my contact information at the end of today's presentation. But I am joined today by Damien, and I'll go ahead and open it up to Damien to introduce himself.
Great. Hi, I'm Damien Reel. I've been a lawyer since 2002. I litigated with the big firm Robbins Kaplan for about 15 years, where I did a lot of high-stakes bet the company litigation, including Bernie Madoff victims that I represented and helping sue JP Morgan over the mortgage-backed security crisis. But since 2019, I've worked for Fastcase, where I've done data science and extracted things that matter from the cases, statutes, regulations, motions, briefs, pleadings that we have, and then worked with our really smart development team to be able to build some of the things that we are going to be talking about today. So really thrilled to be here today.
We are thrilled to have you, Damien. Thank you for taking the time to join us and walk us through some of the Vincent workflows and information and projects that you've been working on with the team. But before we get into Vincent and some of the upgradable content on the vLex Fastcase platform, I wanted to take a step back, a look back at where we've come from. Where did we start with legal technology and information in the legal field in general? So, the legal profession began with books and paper, and research meant physical navigation of libraries where your success depended on mastering indices and digests and the help of the local law librarian. But a single question could take days to answer, and comprehensive research was limited by what you could physically house. Then came the development of Boolean searching in mid 70s to the late 90s, which compressed research time from days to seconds. And the competitive advantage shifted to those who could harness those new tools. And then in the late 90s, early 2000s, the internet helped to democratize access, and web platforms like CaseMaker, vLex, and Fastcase with intuitive interfaces emerged alongside citation mapping tools. And for the first time, we could visualize relationships between cases and access research virtually anywhere and anytime. Now, today, we've entered the era of AI assistance. Large language models don't just find cases, they synthesize principles. They also identify splits in authority and can even draft initial memoranda. And the role has evolved from information hunters to strategic analysts. And these research efficiency gains create new client expectations, and Damien will touch on this in his presentation. But you should always be looking to innovate your practice. You owe it to both yourself and to your clients, because they're going to start expecting a more efficient process. But just by joining our webinar today and learning about how you can implement Vincent AI into your practice and AI in general means that you're still ahead of the curve. You need to take action, but you're still ahead of the curve by being here today with us. We've learned that tools will continue to change, but the purpose remains constant. And that's finding truth and pursuing justice through better informed legal reasoning. And the question isn't whether to adopt these new technologies, but how to leverage them while maintaining the human judgment that defines the legal profession. So the most successful will be those who embrace technology and that human element of judgment, creativity, and wisdom. Now, I am going to move back a little bit. So I know I just wanted to provide a little bit of a story there where it sets you up to where we are in today's world and the things that are changing. But I wanted to now jump into your bar plans. So for many of you, your access in the vLex Fastcase platform is going to be a little bit different depending on what bar association or what bar partnership you have. So I'm going to highlight here which bar plans are available to you. So as I mentioned, depending on what bar you're associated with, you will have one of these three plans. You'll either have the state core plan, which is the primary state content, including cases, statutes, constitutions, regulations, all the primary materials specific to your state, and some related federal content as well. Now, the next level above that would be our US core plan. And I'll show you where these live in the platform momentarily, but with the difference between state and US core, the US core opens it up to all 50 states and all federal content, again, for all those primary law materials, so cases, statutes, regulations, etc. And then we also have a US Core Plus plan, which is the Docket Alarm Essential plan. And that just opens the plan and research that you can conduct in the vLex Fastcase platform to include the docket alarm content. So briefs, pleadings, motions, and order content that you can research right in vLex Fastcase. So with that, I'm going to go ahead and move over to our platform here to show you where that information is. So when you're logged into vLex Fastcase, on the bottom left-hand side here, and I'm using a State Bar of Georgia account since I'm located here in Georgia, but it'll have your bar name, and then underneath that, it will also have your plan level. So here it'll say vLex Fastcase State Core, or in this example, vLex Fastcase United States Core. But then also Georgia is one of the bar plans that has docket alarm essential content as well. So this is, federal, state and federal court dockets across the US. Millions, if not close to 1 billion documents that you can research and access through the platform here. Now, also wanted to provide you with some education on where you're already receiving access to Vincent AI and the powers of Vincent AI in the vLex Fastcase platform. And to do that, I'm going to navigate to a recent case that I was viewing here. So we'll go to this case. And there's two ways in which Vincent is already being harnessed and provided as part of your member benefit here. One of those is through our case analysis section. So through your bar plan, you have access to the case analysis section on any of the cases that you research and find in the platform. And we are harnessing the powers of Vincent AI to provide a summary here, or a case analysis of what is the legal issue, and what are the main head notes of this document and the opinion here, as well as the key paragraphs and key phrases. So again, this is included in your bar plans. Now, one additional way that Vincent is already provided to you, or a portion of Vincent's capabilities, is through our related tab here. So on the document level, you'll see the case analysis on the document level, but if you scroll to the right, you can also find the related tab, which is going to provide you with a list of suggested materials that are similar to the document that you're navigating or that you're viewing here. So just wanted to highlight those two areas for you so you know exactly where you can go to access and see bits of pieces of the Vincent AI tool in action on the platform. But now to provide a much better breakdown and thorough explanation of some of the tools and what Vincent can do for you, I am going to hand it off to Damien here, and while I make sure he is able to present, he'll get started on his portion of the webinar.
Great, thanks. And so as I'm starting to present, we really, if you think about where we are in today's AI-driven world, it used to be that you could get along by not using AI, but I've spoken at, I've given over 100 presentations in 2024, and I've been to many, many conferences, and I speak to so many law firms that say, if my competitors are not using AI, that's fine with me because I'm eating their lunch. So TJ said, you know, that's great that you're here, that you're ahead of the curve. And I would say, yes, it's probably good that you're here and ahead of the curve because your competitors, a lot of them are also here. And so good for you to be able to think that this is a way that you could be able to eat the lunch maybe of your competitors. And TJ, if you could give me a thumbs up or a heads up that you can see my screen before I start jumping in.
Yeah, everything looks good.
Great. All right, cool. So within the vLex Fastcase, you can see this beautiful Vincent AI button. What you do is you click on that Vincent AI button, and it gives you all of these great workflows. Everything a lawyer does is a workflow, whether it's asking a research question and getting a really good answer based on actual non-hallucinated cases, statutes and regulations, and secondary sources, or not just getting an up and down objective answer to the question, but building an argument. That is building a subjective, I guess a slanted, argumentative, taking your facts and applying the law in an argumentative way that you can place into a motion. What if you want to upload a contract and no prompting necessary, be able to upload the contract and get hundreds of pages of good analysis of that contract, and then be able to summarize those hundreds of pages into a one-page summary memorandum for your client? What if you could do the same thing for a complaint? Upload a complaint and be able to get 200 pages worth of good analysis of that complaint, including good research, and then summarize for a client in one page. What if you want to do a 50-state survey in 5 minutes? What if you want to do the same thing for a multi-country survey, including Mexico and Latin America and a bunch of EU countries? What if you want to see version 2 of the contract and how that differs from version 1? Be able to either support my proposition or oppose another proposition. Each one of these is a workflow. I'm going to be working through each of those workflows. The first workflow I'm going to go through is asking a research question. And of course, you could try to ask a research question of ChatGPT, but that's a bad idea. One of the reasons it's a bad idea, Steve Schwartz will tell you, is that it might well hallucinate cases. But even if it doesn't hallucinate cases, here you can see it's given me the Defend Trade Secret Act, but it's not giving me any particular quotations from that act, nor is it giving me any subsections. So if I need to do the legal research anyway, what's the point of doing it with ChatGPT? So here, what if I ask that same question about trade secret law regarding former employees? And what if I scroll to California law? And now I'm going to say, what is a trade secret law regarding former employees stealing customer lists? And I've read it now across actual non-hallucinated cases and actual non-hallucinated statutes and regulations, non-hallucinated administrative decisions, and non-hallucinated secondary materials, like those from the American Bar Association and law reviews. So you can see it's already found 51 of those potential cases, statutes, and regulations. And then it's done a 5-stage review on now 37 of those. That 5-stage review, stage 1 of that is to find actual non-hallucinated text from actual non-hallucinated cases. So here's text for American Paper, here's text for More Life. You can see this text that you see here will be non-hallucinated 100% of the time. Not 90, not 95, not 99, but 100% of the time, this text will be non-hallucinated, and 100% of the time, this case will be non-hallucinated. And you might say, Damien, I've heard a lot about hallucinations. How can you say 100% of the time that it's not hallucinated? And I can say that because this is not created by a large language model. This is not created by AI. This is created by a database search, just like we've been doing database searches for the last 40 years. So 100% of the time, this text will be non-hallucinated, and 100% of the time, this case will be non-hallucinated. So stage 1 is to find non-hallucinated text for each of these cases. Stage 2 then is we ask the large language model, how well or how poorly does this text answer the user's question? And here's how well or how poorly American Medical Distribution answers the question. Here's how well or poorly Neville answers the question. So we give individualized analyses for every single case that you see here and every single statute that you see here. That's stage 2. Then stage 3 is we say, well, if now that you've analyzed it, how well as a percentage, as a confidence score? American paper mostly answers the question, and More Life mostly answers the question. But another case here totally answers the question. Courtesy totally answers the question. So you'll see confidence scores of 100, 90, 80, 70, but you won't see anything below 70, because if it's below 70, we throw it away. So all you see here are 25 cases that are above that 70% threshold. So that's stage 3. Then stage 4 is we say, well, if a case like Neville answers the question, then maybe the cases that Neville cites might also answer the question, just like a good researcher would. So we actually go into Neville, and we've already done the work on the back end to be able to say that Neville versus Chetikov, cites 32 cases. So we do that same stage 1, 2, 3 process on all 32 of these cases. And if any of the 32 are above that 70% threshold, we add that to the list. So we call this going down the tree. We also go up the tree. That is, many cases cite Neville. Sequoia cites Neville, Desch cites Neville. So we do that same stage 1, 2, 3 process on all 253 cases that cite Neville. And if any of those 253 are above that 70% threshold, we add that to the list too. So we call this going up the tree. I've given many talks at many conferences in the last year. So many people on stage say, I don't know when ChatGPT is going to reach human levels of analysis. And I litigated for 15 years. I know 0 humans when they find a case like Neville that answers the question. I know 0 humans that are going to read through all 32 cases that Neville cites. And I know 0 humans that are going to read through all 253 cases that cite Neville. Vincent does both those things in a minute and a half. And it does that not just for Neville, it also does that for More Life. It also does that for Applied Medical. We go down the tree and up the tree for all 25 of these cases. We're doing superhuman work at superhuman speed. That's stage 4. Then stage 5 is to take all 52 of these cases, statutes and regulations, and secondary materials, like those from the American Bar Association and those from law reviews. And we summarize all 52 of these into a memorandum that you see here. And this memorandum reflects what I told my associates when I litigated. I said, when you write a memorandum for me, don't make me wait to the bottom. Give me the answer right up top. So Vincent will do the same thing. We will take all 53 of these cases, statutes, and regulations, and we'll answer your question in one paragraph right up top. Then I would say to my associates, dig deeper into the most relevant statutes, which we do here. And we'd say, dig deeper into the most relevant cases, which you see here. And then large language models are sycophants. They tell you what you want to hear. But we counteract that by saying, don't tell us just what we want to hear. Tell us what we need to hear. Give me the exceptions to the rule. Give me the flies in my ointment. So here you can see if the information is publicly available or readily ascertainable through public sources, then it's probably not a trade secret. A large language model is not going to tell you this out of the box. It will only tell you this because we prompted it to do this here. So if you think about how long would it take an associate to read through hundreds of cases, land on the 25 that are above that 70% threshold, and then turn all 52 of these sources into a memorandum that you see here, probably going to take that human associate longer than the minute and a half it took to build this. And now I can copy this and paste it into an email. I can copy these and paste them into my brief. Or I can download it either as a Word document or as a PDF. And the irony is that it might take Word longer to download and to open than it did to actually create the memorandum itself. But let's see how long it takes Microsoft Word to open, and we'll be able to see what the output is from Microsoft Word as we open it. You'll see the left-hand side here, and you'll see the right-hand side reflected in the Microsoft Word document that you'll see momentarily. Again, you can copy and paste each of these sections, and you can also copy a link to be able to share with your colleagues to say, look at these research results. So as I said, it sometimes takes longer to process the Word document than it is to actually make the memo. Now here is the question I asked at the top. Here's the left-hand side memo. Here's the right-hand side, as I scroll down, here's the right-hand side, all of the legal authorities, including all of the statutes and cases. And if we scroll all the way to the bottom, this is look to the bottom left, a 31-page memorandum created in about a minute and a half. This is not the end of the research, but it's a really good head start. Way better than a first-year associate, probably better than a sixth-year associate or a ninth-year associate. Certainly faster. And now I could be able to read through More Life and read through Neville and be able to get the answer to my question. So that's workflow number one, asking a research question, which gives you an objective answer to the question. But man, I'm a litigator. I like to argue. I like to be able to support my arguments and oppose the other side's arguments. So here I want to oppose the other side's argument, which is arguing that a recording of a conversation without consent violates privacy laws. So what I can do is I can find the other side of that argument and find the other side of the argument in actual cases, statutes, and regulations. I'm going to pull the old baking show trick of pulling one that already opened up, where it said, hey, listen, that's not true because you didn't have a reasonable expectation of privacy, or this is a Zoom call, or you were in a one-party consent state, or you implied consent when you heard the beep, or I'm a journalist. These are all opposition to this, supported by cases, statutes, and regulations. And then at the bottom, you can see that it provides not an objective answer, but a subjective argument on how that proposition, that a recording is without consent, that proposition is wrong. So the previous one, answer a legal research question, that is an objective answer. And then legal proposition is a subjective argument, either supporting or opposing a proposition. Then we can go full on to argument mode. That is my arguments. I need facts. So here are my particular facts representing my client, Sarah Johnson. And Sarah Johnson met with Michael Brown. And during the conversation, Sarah disclosed personal details. And then unknown to Sarah, Michael put a smartphone on the table and then started recording without Sarah's knowledge. So here are my facts. And then I put what my goals are. I want to be able to show that Michael's recording without consent violates privacy laws. So what Vincent does after I do those two things is it gives me cases, statutes and regulations, and secondary materials that relate to my facts and goals. And then it does what every lawyer does, is applies those facts to the law. That is, here are an introduction. Here are the most relevant facts of those I provided. Here are the principles that matter most. That is federal statutes that you see here, state statutes you see here, and then common law principles like expectation of privacy, along with the cases that cite those common law principles. And then everything a lawyer does is applying the law to the facts, or if you prefer, applying the facts to the law. And here you can see that because the defendant recorded the conversation without the plaintiff's consent and under the principle of this statute, it's likely the defendant's actions constitute a violation of privacy laws, and that the plaintiff, my client, had a reasonable expectation of privacy during the conversation, as supported by these non-hallucinated cases. And what are my most relevant submissions under each of the statutes? What are my arguments in the alternative? What are my areas of risk? You can say the argument is potentially weakened by the fact that Katz and Jones have been superseded by statute. Here you can see we haven't just collected the cases and the text from those cases, but we actually, as cases come in, we say, oh, Whittington noted that this case, Jones, was superseded by statute. Or this case, Cockrum distinguished Bartnicki. So we provide you with the citator is what it's called, of whether this case is good law or not. And we take this into account when we actually make the memorandum. That is, we tell the large language model, we tell Vincent, yes, acknowledge that Roe v. Wade was the law of the land for decades, but also tell the user that Dobbs overruled Roe v. Wade. So we now can do this, saying what cases were distinguished, what cases were superseded by statute. And this is something that ChatGPT is not going to be able to do, and query how long it will take for ChatGPT to do this. Decades? Who knows when they're going to do this. So this is building an argument, being able to take facts and goals, apply it to the law, and then give an answer here. Now, beyond building an argument, what if you want to be able to get an answer to a question across all 50 states in about 5 minutes? Here I've asked about right to work laws and how they affect union membership and dues. Vincent's smart enough to take multiple questions and say, hey, those are actually two questions. Question number one, right to work laws, and question number two, union membership. And so what it's done is created not just 50, but 100 memoranda. 50 memoranda for question number one, plus 50 memoranda for question number two. And now here's the answer for question number one for Alabama, Alaska, Arizona, Arkansas, all 50 states. And if I want to be able to find Florida, here's Florida. Cases, statutes and regulations, and secondary materials that relate to Florida's right to work laws. If I want to be able to see the full memorandum for Florida, here's the full memorandum, including statutes, cases, and secondary materials. We do that not just for Florida, we also do that for Texas and every other one of the 50 states. And then what we do is, much like a good researcher would put that into a table, we do that too. Right to work laws? Yes, no, yes, no. Here are the statutes, here are the cases, here are the exceptions and limitations to that rule. Now I could take all this and download it as an Excel spreadsheet. And we do that not just for question number 1, but also question number 2. How do they affect union membership and dues? And Vincent is smart enough, that is, we've programmed Vincent to say, look through those 50 memoranda and give me columns that are most relevant to that put into our columns. So here you can see Vincent said, hey, I saw a lot of these memoranda talk about union membership being voluntary or not. So now here's voluntary membership. Are dues payments voluntary? These are all made on the fly that Vincent has looked through and be able to find the things that matter for all the states. And now what you can do is you could be able to prompt to be able to say, hey, draft a contract provision that provides a good result for avoiding the right to work laws in both Alabama and Texas. And now here's a contract provision to avoid right to work laws in Alabama and Texas. And then you could say, now draft a contract provision that incorporates the provisions and learning from all 50 states. And now here is a comprehensive 50-state survey. A contract provision for the 50 states that incorporate learnings from the 50 states. So not only is it a 50-state survey, but it's a way you can reason with that 50-state survey. If you've ever built a 50-state survey, and I've built many of them, you know 2 things. Number 1, they take forever. It could take weeks or months to do a 50-state survey. Number 2, that survey is obsolete as soon as the ink is dry, because tomorrow there's going to be a new case and a new statute and a new regulation, and you have to go through the pain of thing 1 all over again. So this is not going to take weeks or months. This takes 5 minutes. That's pain point number 1. And pain point number 2, because it takes 5 minutes, you could run it again tomorrow or next quarter or whatever cadence you want. And so law firms that sell 50-state surveys as flat fees say, this is amazing. We're going to shrink our cost for these surveys and increase our profit margins. So this is very exciting for law firms that sell via flat fee. You know who else it's also excited for is the Fortune 100 and Fortune 50 companies we sell to, who say, wait, why would I even hire a law firm to do this? Why don't I just hire somebody internally to be able to run this every week, quarter, whatever cadence I want, and then have somebody validate that all of these cases, statutes, and regulations are valid. So for the law firms that get it, that realize that this is not ChatGPT, for those law firms that get it, they're going to be able to make a lot of money selling 50-state surveys to their clients before their clients realize they can do it themselves. So that's a 50-state survey. What if you could do the same thing with multiple countries? What if you want to know about privacy laws and online advertising across UK, Ireland, France, Spain, Portugal, Italy, EU, Mexico, Brazil, Colombia, Chile, Hong Kong? We just keep adding more and more of these jurisdictions. So you might say, well, Damien, I don't do international law, I just work in Florida. No, you don't do international law today, but your clients do work in Mexico. Your clients maybe do work in European Union or Colombia, Chile. So you could imagine that today you don't give any legal advice, but you could say, hey, I now have access to EU law and Mexican law. And so now you could see that it's given me the answer about privacy laws related to online advertising, and I've run it across Spanish law. So here are Spanish cases, statutes, and regulations. And you can see that we've round-tripped it back into English. So to be clear, I've asked an English question across Spanish law and gotten an English answer. And it's done that because I've set my language settings to English. I could have just as well set my language settings to Spanish, or Catalan, or Italian, or French, or Portuguese. So to be clear, you could ask a Spanish question across French law and get a Spanish answer. We're the only game in town that allows you to ask a question in your native tongue across foreign language text and get an answer in your native tongue. And that foreign language text could be French, could also be Portuguese, could also be Brazilian Portuguese or Mexican Spanish. There are any language that you see here, we round trip it back to your native tongue. We're the only game in town that allows you to do that. And if you think about how many companies in the world have comprehensive cases, statutes, and regulations in the United States, there are only 3 companies in the world that have comprehensive cases, statutes, and regulations in the US. Those 3 companies are Thomson Reuters, LexisNexis, and us. And you might say, well, Casetext, CoCounsel, before they merged with Thomson Reuters, where did they get their data? And the answer is from these guys. Every day we at Fastcase gave our cases, statutes, and regulations to Pablo and Jake from Casetext, who then turned that into a $650 million company they sold to TR. But what Jake and Pablo didn't have is data from the European Union, Spain, Italy, France. Also didn't have UK data. We've been collecting that since 1985. So we have UK data back to 1235. They also didn't have the tax havens of the Jamaica, the Bahamas, or the Cayman Islands. They also didn't have data from the banking powerhouses of Hong Kong, Malaysia, or Singapore. So in the US, only 3 companies in the world have these comprehensive cases, statutes, and regulations to do a 50-state survey. But to do a multi-country survey with the depth and breadth of vLex, there's only one game in town that has all these data. And there's only one game in town where you can ask a question in your native language across foreign language text and round trip it back into English. So that is a multi-country survey. What if you want to upload a complaint and be able to get many pages of output, no prompting necessary? And this reflects what Steve Jobs said, that the best user interface is no user interface. And I agree with Steve. And Sam Altman was asked on stage, what do you think of the ascendance of prompt engineering as a field? And Sam Altman said, I hope that's not a thing in a year. Because if I'm doing my job correctly, you won't have to be a prompt engineer. All you have to do is ask me a question and ChatGPT will give an answer. So I agree with both Steve Jobs and with Sam Altman that if we at vLex are doing our job correctly, you won't have to be a prompt engineer. Instead, all you have to do is upload a PDF into Vincent. Vincent will recognize, oh, that's a complaint alleging copyright infringement. And Vincent will give you these buttons, no prompting necessary. And these buttons reflect what I as a litigator did at Robbins Kaplan for every single complaint I received. I would say, what are the claims that are being alleged? What are the facts supporting those claims? Who are the parties? What are they looking for? Are they looking for money or are they looking for an injunction? Each one of these is an extractive task, and we do this no prompting necessary. Then beyond extraction, we go to ideation. What legal defenses can I mount for each claim? What questions should I ask my client to help them win? This is the work of the lawyer, and we do this again, no prompting necessary. Then beyond extraction and ideation, we go to legal research questions that are customized to this complaint. It says, Vincent says, oh, that's a copyright complaint. So maybe you want to know about statutory and actual damages in copyright. Maybe you want to know about fair use or transformative use. These are all legal research questions, again, on the fly, no prompting necessary that you're given. So as a user can select all of these, and Vincent will give you a memo talking about actual damages or statutory damages, along with non-hallucinated cases, statutes, and regs. Vincent will also take out all the claims and do an analysis of those claims, including statutory bases, whether it's state law or federal law, which facts are being alleged under this claim, and who are the parties under this claim. And it gives a nice memorandum with analysis of all those claims. Then beyond that, Vincent will tell you who did what when, according to the complaint. We did this here for one document. We could have just as well done it for 5 or 100 documents. How many billable hours are spent saying who did what when? Then for each of the claims, we say, what are legal defenses that can be mounted for the claims? Well, for copyright infringement, maybe you want to argue fair use. This is what fair use is. You can say the use of the New York Times content by OpenAI was to train the models, and that's fundamentally different than the original publication. And AI-driven insights don't replicate the original journalistic function. That is a good legal argument, a good legal defense. And we give that good legal defense for every single claim that you see here. How many billable hours are thinking about what good defenses are and good facts to be argued? Then I say, what questions should I ask my client to help them win? Here I represent OpenAI. So questions for them are, what was your training data? What were your sources? Did you get permission from the New York Times? Those are good questions for copyright infringement. We did the same thing for every single claim in here. You'll want to know the answers to these before you answer the complaint. Then when I was at Robbins Kaplan, I would go to my document management system and I would try to find cases like mine so I don't have to recreate the wheel. This is better than any firm's document management system. This is 895 million dockets and documents across all the federal courts and 38 state courts. So each of these 5 cases is a case like mine. It's a large language model copyright case. This is better than any firm's document management system. This is a universal document management system of all the biggest law firms in the world and all of their filings. So if I want to go to any one of these cases, daily news, I can click on that case. And then Vincent will say, that's a Southern District of New York case. That is a copyright case. And we've extracted everything that matters from that case. We've extracted every complaint and every answer in green. We've extracted every motion in blue. We've extracted every order in orange. And we've extracted whether that order has been granted or denied or partially granted, partially denied. Our competitors do that for 5 or 10 different motion types. We do that for over 200 motion types. So now my client can say, what are the odds of winning this motion to consolidate? When I was litigating, I would say the odds are pretty good or not bad. But wouldn't it be better to say, well, the odds in federal court are 81%, but in this court, where we are right now, it drops to 86%. But for this judge, we don't know. But for copyright cases, the odds are about 60%. Which would you rather have? Would you rather have a pretty good or not bad? Or would you rather know that Sidney Stein only grants 95%, but 90% of motions to seal here? Much better to have an analysis that is numeric. And then if I want Sidney Stein to be able to grant my motion to seal, I can move from analytics mode to research mode. That is, I could be able to find cases like mine, 65 cases like mine, that have motions to seal that have been granted by Judge Sidney Stein. So I can copy and paste and say, Your Honor, just like the case you decided in January 17th, or just like the case you decided on January 10th. Copy and paste. This is a universal brief bank where you have better resources as a solo small lawyer than the biggest law firms in the world have in their document management systems. Now I have 5 cases like mine. And for every one of those 5 cases like mine, we actually do an analysis of that. Here's the daily news. Here are the claims for the daily news. Here are the facts in the daily news. Here's the way that the daily news is similar to the New York Times case, similar jurisdiction, similar defendants. Here's the way the daily news is different than the New York Times, different plaintiffs, different copyrighted works. We do that analysis for all 5 cases like mine. Then beyond that, we say, who are the parties? Well, here's the New York Times, here's Microsoft, here's all the OpenAI entities, including wholly owned subsidiaries and holding companies. Then beyond that, what are they looking for? They're looking for money, they're looking for an injunction, they're looking to destroy ChatGPT altogether. Then maybe I want to move to a better venue that's more favorable to my client. Maybe I want to know the legal bases for all the claims. Maybe I want to be able to prompt. So here's me prompting to get my motion to dismiss on the idea expression dichotomy. Here's how I win under this non-hallucinated case. Here's my motion to dismiss, saying that you essentially hacked the system by uploading the first 8 paragraphs of the article. Here's how I win under this non-hallucinated Sony Betamax case. Maybe you want to see a deposition outline of Sam Altman, OpenAI CEO. Hey, Sam Altman, how do you collect and curate your data? What are your sources? What if I want a deposition outline not just for Sam Altman, but also for Microsoft CEO, Satya Nadella? Hey, Satya, why are you partnering with OpenAI? Why are you investing in OpenAI? How long would it take a human associate to do this work? I would say Robbins Kaplan, this would be maybe 200 hours worth of billable time. As you can imagine, plaintiffs' lawyers love this. That is, contingency fee lawyers love this. Hourly lawyers, that is, defense hourly lawyers, love it a bit less for the reasons you can imagine. But who really loves this are the Fortune 100 and Fortune 50 companies we sell to, who say, this is amazing. We're going to do 2 things. First thing we're going to do is we're going to say, for old complaints that we received over the last year, we're going to run those through this. Then we're going to compare these 200 pages with what our lawyers did. And we're going to say, what did our lawyers do on top of this 200 pages, if anything? If the answer is nothing, they didn't do anything on top of these 200 pages, that's going to say something. And then what did these 200 pages have as insights that we wish our lawyers had told us? If the answer is a lot, that's going to say something too. So that's going backward in time. And then they said going forward in time for new complaints they receive, they said they're going to take these and before they give the case to their outside counsel, they're going to run it through this. Then they're going to give these 200 pages to their outside counsel. And they say, they're going to tell their lawyers, what can you do on top of this? Because that's all we're going to pay you for. We're not going to pay you to recreate this 200-page wheel. So for the law firms that get it, that realize we're in a new world, This is not ChatGPT. This is a built for lawyers by lawyers, doing everything that lawyers do. Lawyers that get it realize that now this is a dramatic shift between me as an external counsel and my clients, because now I can serve them better, faster, stronger. And my corporate clients are now going to get better work product, and I could be able to steal work from my competitors who are not using tools like this. So Salesforce, which you know, they've done public podcasts. So the head of legal operations, Leo Mergel, who has said it publicly that Salesforce, when they use Vincent, they say it used to take 3 weeks to get these kind of insights, to do these 200 hours worth of work. But now he said it doesn't take 3 weeks. He said on day one, I upload the complaint, get the 200 pages worth of analysis, and then on day one, I say to my counsel, hey, what do you think of this this defense of fair use? What do you think of this defense of lack of misappropriation or lack of dilution by tarnishment? Now on day one, I could have these insights. It doesn't take 3 weeks. So this is analyzing a complaint. What if you could do the same thing for a contract? Here's a merger agreement between Microsoft and LinkedIn, and Vincent gives different buttons. Again, no prompting necessary. Things that contract lawyers care about. What are the definitions? Give me overlapping clauses. How can I mitigate risk? Give me language that's client hostile. Give me post-closing obligations, fallback positions, dates and a timeline, and a compliance checklist. Again, no prompting necessary. You get these good analyses. And then in purple are legal research questions that are customized to this particular merger agreement. I want to know, okay, what is, maybe I want to know about the antitrust implications because this is a big merger under US law. Maybe I want to know about LinkedIn's duties of directors to their shareholders. Now here's a research memo talking about the antitrust implications of a merger under US law. And here are all of the analyses of, for example, defined terms. Here's an analysis of all of the inconsistencies and overlaps. Maybe you want to check 8.1e versus 8.1g. Here's the problem. Here's why it's a problem. Here's a way to revise it to make it better. What if you want to be able to, for a contract, figure out client hostile language? That is stuff that is bad for imbalanced obligations or for excessive penalties or for restrictive covenants, and maybe ways to be able to suggest to be able to have clarifications or mitigating of the risks. Maybe what if you want to be able to see risk analysis of financial obligations, of operational limitations, of compliance and regulatory risks. Each one of these things are things that you can go through and be able to give your clients a much better analysis and at a much faster speed. What if you want to do the same thing for diligence? Here's a bunch of diligence documents and be able to then find out main revenue streams, growth rates, gross margins, etc. What's their corporate structure, what's IP, etc. What if you want to be able to find version 2 of the contract and how it differs from version 1? It looks like here are the changes in a summary. Here's how it changes the risk to my client. Here's the particular provisions that have been changed. And here's a table of all those changes that could be downloaded as an Excel spreadsheet. Here's a nice version 1, version 2 of the analysis of the red line. What if you wanted to upload a deposition and get a detailed response? This is just a random deposition, and Vincent gives you these buttons, no prompting necessary. And then I could be able to say who did what when. So now here's a table of who did what when according to the deposition. And here you can see is the actual PDF itself. And then it has actually being able to find the particular provisions of that PDF as it pulls up, where it comes from. So this is a trust but verify, where it's going to be able to pull up the Trust University case complaint and be able to validate this case text where it comes from. So now I could be able to say who did what when. I could also be able to say what are the themes in this deposition, his expertise, his value and visibility. And again, now here is a nice PDF of whether he's a real estate expert or not. And then you could be able to say, okay, here is stuff that you can put into a brief, pleading, or motion. Here's copy and paste into your brief. Here's a question from the lawyer, the response from the deponent, page and line numbers, as well as the source in a deposition. This is now something you could be able to separate into different themes, copy and paste into your brief. This is analyzing a deposition. What if you want to be able to ask a question of 895 dockets and documents, 895 million dockets and documents across all the federal courts and 38 state courts? Now, if you have this question or your client has this question, think about how you might answer it. What's the average case length for civil rights cases that settle in the Central District of California? If your client asks you that, what would you say? How would you even find the answer? Here we have California Central District Court cases. And in each of these, you can click into it. And we have the fact that it is a civil rights case. We have the date it was filed and the date it was terminated. We have the fact that it was a stipulation to dismiss, which means it was settled. Therefore, we say most cases settle within 2 years. Here you can ask a plain language question across all federal and 38 state courts, find it in structured data, and be able to get an answer. You could do the same thing for a lawyer. What if you want to know about David Boies and his experience in the Southern District? Here are David Boies cases in the Southern District, including the role he played, the status of the case, whether what the background is, which motions were brought, how long the case last, what the outcome was, how complex the case was, who were the experts, how much money was at stake. And we do that for all these cases. And then we summarize it here. Turns out David Boies does a lot of antitrust cases, a lot of securities cases, a lot of contract disputes. You can click on any one of those here. What if you want to do that not just for a lawyer, and by the way, this lawyer could be your law firm's lawyers or opposing counsel's lawyers. What if you want to do the same thing for pitching, here's what my firm has done, or here's what opposing counsel has done. Here's Quinn Emanuel's cases in the Central District, including that they do a lot of product liability cases, a lot of IP, a lot of copyright. What if you want to do the same thing for either your client or the other side? Here's a bunch of their cases. Turns out that they do a lot of motions, and here's some of them. What if you want to figure out for this judge that you're in front of? Here's this judge's experience. Turns out Judge Susan Richard Nelson does some ERISA, Fair Credit Reporting Act, civil rights cases. We are the only game in town that does this profile of party. We're searching actual non-hallucinated docket data and be able to find information about lawyers, their law firms, their parties, and just to be able to ask any question across average case length for civil rights cases. Ask a plain language question and get an answer. I worked for federal district court judges, Chief Judge Michael J. Davis in the District of Minnesota. I also worked for a state appellate judge, Chief Judge Toussaint. And for them, I would draft bench memos where I would say, Your Honor, plaintiff says, defense says, Judge, I think you should say. The problem is that that would take me about 12 hours because the plaintiff would say it on page 1 and the defendant would say it on page 20. So it would take me 12 hours to connect the dots. But I thought when I worked at vLex, I thought we can do that actually in minutes. So here is a judge and adjudicator workflow, a bench memo workflow, where I've uploaded the memoranda, plaintiff says, defense says, and Vincent is able to separate that into each of the legal issues. This is what plaintiff says, this is what defense says. Here's a summary of plaintiff's argument. Here's an excerpt verbatim from the argument. Here is the citation to the brief where they say it, and citations, etc. So now here's a bench memo, not only separating the legal issues and their arguments, but also the weaknesses and ambiguities of plaintiff's case. Plaintiff is weak on pre-existing hazardous conditions and the knowledge of those conditions. Defendant is weak, saying this is an open and obvious hazard and this pre-existing condition. We also provide what are questions you should ask the defendant. Hey, how do you reconcile the open and obvious hazard defense with the plaintiff's claim that the fresh snow obscured the hazard? These are all good questions for the plaintiff and for the defendant. These are good not just for the judges, but it's also good for you as a lawyer and your clients, because you can give this memorandum to the clients and say, you know, we've got some good things for us and we've got some bad things going for us. That is, we have some strengths and we have some weaknesses. This is what this is what the judge is going to be thinking about. And then you as a lawyer can say, what are the things that the judge might ask me? And I can shadow box with myself and be able to say, yeah, maybe I'll be ready to be able to answer any of these questions. And of course, judges care about undisputed facts because they put those into the brief. They also care about disputed facts, especially for summary judgment. And here you can see that I, as a judge, can prompt. to say, based on the above, who has the stronger argument? Base your opinions on the facts in the PDF as well as the law. And here it summarizes the plaintiff's argument and the defendant's argument, and then it evaluates those, the strengths, and say overall defendants collectively have a strong argument under the continuing storing doctrine, but their position could be vulnerable if the plaintiff can substantiate the claims for pre-existing hazardous conditions. And I, as a judge, can then say, has either defendant shown no genuine issue of material fact for summary judgment? And here's an analysis of various genuine issues of material fact. And then here you could say the genuine issue of material fact suggests that maybe summary judgment may not be appropriate. It's not telling the judge how to rule. But here now I, as a judge, could be able to say, draft a judicial opinion denying summary judgment, based on your analysis and non-hallucinated law. And now here is this. You can see that these things are not Vincent out of the box things, because I think we out of the box should say, Your Honor, plaintiff says, defense says, but we should not say, Judge, I think you should say. But if the judge wants to do that, we're not going to keep them from doing that. So this bench memo workflow is very good for not just the judges that use our system and not just the arbitrators that use our system, but also for the litigants and their lawyers who are in front of judges to be able to see the strengths and weaknesses of their cases in an objective way, to be able to prepare for a memoranda and to prepare clients for either winning or for losing. Each one of the things I just mentioned is a workflow. Being able to say, here's a research question done in a minute and a half. Here is a subjective argument that takes your facts and applies them to the law. Uploading a contract, being able to get 100+ pages worth of analysis in 5 minutes. Doing the same thing for a complaint. 50 state surveys or 50 multi-country surveys, 17 country surveys, done in minutes. This version versus that version. Explorer proposition. Here, Explorer collection is something we haven't talked about, is where I could be able to take hundreds or thousands of documents. Here I have 954 files, that's a trademark case, or 47 diligence files. And then I can ask questions of those 954 files. I could say, show me all the times where there was consumer confusion, and be able to explore in this collection of hundreds or thousands of documents. I want to be able to find cases like mine, or documents like mine, motions like mine, complaints like mine, answers like mine. I want to do a chronology of 5, 10, 50, 100+ documents. I want to be able to summarize this document quickly. I want to upload a deposition and get a good analysis, no prompting necessary. I want to be able to find, ask a question saying how long these types of cases take, or show me any jury verdicts related to that. I want to be able to find what my clients have done in the past or what opposing parties have done in the past. I want to profile the opposing counsel. What experience do they have in this area? Have they made any contradictory arguments in these other cases? I want to find the same thing with the law firm. Has this firm argued the other side of this argument? I want to find out about my judge's experience and say, Your Honor, this is just like the case you decided yesterday. I want to find cases like mine so I don't have to recreate the wheel. I want to do due diligence. I want to anonymize documents. I want to see bench memos. We just keep cranking out these workflows. So this is Vincent. Every single thing a lawyer does, we keep cranking out a workflow. And with that, I think maybe I will pass it back to my colleague, TJ, who can be able to talk through the next steps.
Yes. Well, thank you so much, Damien. It is safe to say that, well, I won't say the possibilities are endless, but quite near with Vincent and the workflows and just the general platform, what we can do with that. So, I mean, just from watching that, many people will walk away with a lot of different things that they can try out on their own. And to do that, I wanted to show you how you can start to really get into Vincent AI and explore that yourself. So the easiest way is going to be through our free trial. We are offering a 3 free-day trial to anyone who has not already done so by right here in the home page. So there's a card on the top left. It may not be exactly in this location. You can also just generally click on the Vincent AI tool to start your 3-day trial here. Make sure you have enough time to dedicate to really get in there and explore to see if that's something that you incorporate in your practice. From watching Damien, I think it's safe to say that it is. But I also wanted to mention that our contact information. The only question I have currently is regarding the cost. So I wanted to highlight our contact information slide to make you aware of how you can reach out about costs. And there is a discount for bar members. So if you want to reach out to ask questions about cost, it's not a one size fits all. So reach out to Alex Seymour. She's one of our account representatives here who can answer any questions about costs for Vincent, as well as set you up with a one-on-one demo, discuss practice area specifics for you. But I've also provided here our just general support contact information if you want to reach out with any questions while you're exploring the vLex Fastcase platform or vLex platform, helpdesk-us@vlex.com, and my personal contact information here. So happy to help point you in the right direction, get you to the best person on our team to answer your questions or answer those myself. And with that, we'll leave it open here for the next few minutes to see if any additional questions come in. I'm not seeing any currently, but we will, as I mentioned, leave that open for just a few minutes. And
sure. When I was an education major, and so my professors in undergrad would say, wait an uncomfortably long amount of time for people to ask questions. So we can wait that uncomfortably long amount of time for people to ask questions. And while we're waiting for that uncomfortably long amount of time, and please do ask your questions in the chat. I would say that some people might be a bit terrified is maybe a decent word with all the things that Vincent can do, saying, gosh, I've used ChatGPT and it doesn't do this, or I've used competitors and it doesn't do this. So terrified is one emotion that you might be feeling, but I would say another feeling should be excitement. This is a way that you could be able to do more work and better work for your clients. And if you are a contingency fee lawyer, or if you're a flat fee lawyer, these are the best days you've ever had, because now you could be able to shrink your costs and be able to increase your profit margin and spend less time on your work, so you can actually get home at 5 p.m. to have dinner with your family. And you can actually take those vacations and not have to work over the weekend, because 12 or 200-hour tasks are shrunk down to minutes. So I would say terrified is one emotion that you might want to feel, but excitement is maybe another. That my friend Casey Flaherty says, we as lawyers do a lot of thinking and we do a lot of thunking. And AI can do a lot of that thunking for us, leaving just the thinking to be able to do. So I think that this is maybe the most exciting time for lawyers that we've ever had, because a lot of the thinking, a lot of the drudgery goes away, and we can then be left with thinking and be able to do the best parts of our job and actually go home for the weekends and be able to spend more times with our family and doing other things we love.
beautifully said. Well, I think we'll, again, just keep it open for the next 2 minutes. Anybody who has any questions, I don't have any additional ones there. One last note, and correct me if I'm wrong, Damien, but also multimodal uploads to the platform. You can upload audio files, video files there, and start to ask questions from that file and transcript right in the platform as well.
That's right. I should have mentioned that. So you can imagine 2 use cases out of the box. You can imagine if I have a hearing and the judge allows me to record that hearing with my smartphone, I could take that audio file and then upload it. It transcribes the audio file and gives a summary for your client to say, how did the hearing go? So that is use case number 1. Use case number 2 is I could be able to take an interview with my client that is being recorded, transcribe that interview, and then be able to do analyses to be able to say, what are potential causes of action that come out of this? What are some potential, weaknesses? What are some potential follow-up questions I'll want to be able to ask of my client? So this idea of multimodal, which means that you can take audio files and video files, and you can upload them and then turn them to text and then reason with them. That multimodality is something you're not going to see in many or any other of our competitors.
All right, well, I think with that, we'll go ahead and sign off here. Thank you all so much for taking the time again to join us for today's presentation. It has been recorded, so it will be sent to you via email once that recording is made available. But in the meantime, if you have any questions or you want to just learn more, please do not hesitate to reach out to us. We would love to speak with you. Thank you, Damien, and thank you all for joining us.
Thanks, everybody.